So this Nipsey Hussle murder trial is now in the books. The jury has spoken. They returned a verdict of guilty of first-degree murder. And so I want to break down some of these issues. My name is Jamahl Kersey. I am a criminal defense attorney. And so, I just want to get into some of these issues that I think, actually, I know left a lot of you scratching your heads. The reason why I know is because just looking through the comment section, a couple of the common themes were, why did this case even go to trial? There's no defense whatsoever. How are we even here? And so if you're like me, it probably kind of struck you as odd when his defense counsel just came out saying that his client did it. He basically came right out the gate and admitted, hey, Eric Holder shot and killed Nipsey Hussle. But basically their defense was, hey, this is not first-degree murder, but rather it is voluntary manslaughter. And they tried to go with a heat of passion defense. Now, I'm gonna take you guys to law school without having to go 6 figures into debt. So let's get into criminal law 101, and we're talking about the heat of passion defense. So if a person is charged with first-degree murder, then as a defense, they could argue that, hey, I was not acting with the requisite intent to kill or the requisite malice that would be required for first or second degree murder. And so in this situation, you would be arguing heat of passion. Now, the classic textbook heat of passion law school example would be this, where a man comes home from work. So he comes home early, finds his wife sleeping with another man, and in a fit of rage, he beats the guy to death, right? He dies right on the scene. So at some point, 911 is going to be called, and then the police are going to respond, and they're going to arrest him for murder. Now, his defense attorney is going to say, no. This is not murder. This is actually voluntary manslaughter. Why? Because he was acting in the heat of passion. So yeah, the woman that you made vows with is, laying in bed, sleeping with another man. We have accepted generally that that's going to be sufficient provocation to send a man in such a rage where he's not able to think rationally and coolly. And so therefore we have accepted that this could be a voluntary manslaughter versus a murder. The problem in this case is that there was just way too much time between the provocation, Nipsey Hussle calling Eric Holder a snitch, or even alluding to the fact that he might have been a snitch or had heard information that someone said that he was a snitch. Whatever that conversation was, that's what the defense was saying was the provocation, which then sent him into this rage, which then led to him killing Nipsey Hussle. The problem is that, as the defense basically said, he phrased it as a mere 9 minutes. But I'm sorry, 9 minutes is a long time. And so if we go back to the class example of the guy who kills the man who's sleeping with his wife, even in that situation, listen, there's what's called a cooling off period. We've accepted that there can be a heat of passion defense if it happens basically within that instant. But let's just go back to that same example and say, instead of the man grabbing the lamppost and beating the guy to death, instead he goes right back down the stairs, he goes outside, he goes to his shed, opens a safe, pulls out a gun, loads the gun, closes the safe, goes back upstairs, and then puts 5 bullets into the guy and kills him. Now we're gonna say, no. We acknowledge that what you saw would be sufficient in terms of a provocation standpoint, but there's been far too long of a cooling off period, right? So during that time that you went downstairs and grabbed the gun and loaded it and went back upstairs, you had more than enough time to really think this over. And so when you decided to go upstairs and shoot this guy, now we're going to consider that to be murder. So we're not going to allow you to use the heat of a passion defense. Well, I mean, you can use the heat of passion defense, but a jury's just not going to buy it because they're ultimately instructed about this cooling off period. So I think one of the main issues in this case for Holder is that we don't know if the jury found that him being called a snitch would have been sufficient provocation. They probably didn't even find that there was sufficient provocation. If they did find there was sufficient provocation, there's just far too long of a time gap. 9 9 minutes is just way too long. I mean, think about all the different things that you can do in 9 minutes. If you run fast enough, you can knock out a 2-mile run in 9 minutes. If you're not, you could at least run a mile. You can have a whole full-on sex session in 9 minutes, right? And so there's a lot of different things. If you just calculate 9 minutes, you could get through 3 songs on the radio in 9 minutes. It's just way too long. And so that's why, you know, for me, once I saw that that's where they were going with their defense, I knew that this just had zero chance at being successful in front of this jury. The other point that we saw was people questioning, like, why is this going to trial? You know, the DA has all this evidence. It's clear that Eric Holder killed Nipsey Hussle. Why are we even in trial in this situation? So there's 2 points that I'd like to address on this issue. And the first one has to do with constitutional rights. So everybody in this country has the right, if you're charged with a crime, you have a right under the 6th Amendment to a speedy and public trial in front of a jury. There's no exceptions to our 6th Amendment right. It doesn't say, well, you have a right to a trial, but if we don't like what you did, then you don't have that right anymore. Or you have the right to a trial, but if the evidence is super strong against you, then you don't get that right anymore. No, there is no exception, and we have to be very careful in terms of this idea of picking and choosing who gets the 6th Amendment right to a trial. So Eric Holder was very much in his right to demand that the government put on the evidence pointing to his guilt. So it's just very important that we acknowledge that, yes, even though the evidence may be overwhelming against a person, they still have a right to trial, and we can't start to question that person exercising their right to trial. Because listen, I mean, it wasn't always the case in America that there was the right to a trial in front of a jury, right? So the government, you know, with all its infinite power, could say, hey, you committed this crime and you have no right to put it in front of a jury to sit up and make the decision to be fair and impartial, listen to the evidence, and them determine whether you're guilty or not the government just saying you're guilty and therefore you're guilty. So we definitely don't want to start to question a person's election to go to trial. So then that's the legal constitutional right issue. The other one would just be the practical issue of going to trial. Why wasn't this resolved by a plea agreement? Why didn't he just plead guilty? Why didn't he just take a deal? Well, the thing that you have to understand is, yes, in general criminal cases, after a person is charged and the DA then turns over the evidence to the defense, they will then shortly after that come with an offer, right? And so the offer is generally going to be better than what it would be if you go to trial and lose, right? So there's an incentive for a person to take a deal versus take their case all the way to trial. However, in cases like this, I mean, you have to understand, Eric Holder killed somebody and actually injured 2 other people. In a case like that, the DA generally will not make an offer. So they will not offer you any sort of deal. So what ends up happening is if the defense, if there's any hope or any desire to reach a deal, then the defense has to make the proposal for the deal. And so what the defense would have had to make as a deal or make as an offer would probably be in the neighborhood of 40 years, right? So anything less than 40 or high 30s just would have no chance at being accepted by the DA because the number of victims, because of the nature of the case. And then on top of that, the stronger the DA perceives their case as being, the more rigid stance they're going to take in negotiations, just like anything else. If they don't have difficult issues in terms of, you know, their witnesses or evidentiary issues, or there might be a misidentification issue or whatever the situation is, if they feel very strong in their case and they're not really going to be inclined to make what would be a favorable deal, it's going to be very difficult from a practical standpoint for the attorney to convince their client, like, hey, if you don't want to go to trial, the only offer that we can realistically make is for you to plead guilty to murder and accept a 40-year deal. I mean, that's just really hard to stomach. So then you have no choice but to go to trial, right? So if both sides can't agree, then the case has to go to trial, and that's why you're there. So you could almost say that it was, in this particular trial, just them sort of going through the motions. But again, we just can't question a person's right to go to trial. As much as we hate what they did, as much as we may despise them for what they did, they have a constitutional right and we've got to honor that. So that's just some insight from a criminal defense attorney. I hope you learned something from this. If you did, make sure you hit that like button, subscribe to the channel, hit the notifications button so you never miss a new video when it drops. As always, I want to thank you for watching, and till next time, peace.